Hello learners, I am Dr. Rumi Ahmed, Associate Professor of Law in GIMS Engineering and Management Technical Campus, Greater Noida. Today we will discuss Section 14 of the Hindu Succession Act, on which the courts repeatedly expressed their unhappiness at the language of Section 14 subsection 1 and Section 14 subsection 2. Section 14 subsection 1 removes the statutory incapability of a woman to hold property as an absolute owner. The position before the enactment of the Hindu Succession Act was that, barring few exceptions, a woman could not take an absolute ownership in property and a compulsory limited ownership was imposed on her. But after the enactment of Hindu Succession Act, the statutory disability to acquire a full ownership is removed, and depending upon the terms and conditions of the grant, a female can acquire either a limited or an absolute estate. A female's position has been brought on par with a man. Question arose, who is an absolute owner? An absolute owner can make any kind of disposition of his or her property in favor of anyone under Hindu law. He can sell it, gift it to anyone, like to a relative, friend, a charitable institution, or for animal homes, or for a religious purpose, or he can bequeath it in favor of a relative or a friend or a stranger. What is removed by the Hindu Succession Act under Section 14 is the inability of the recipient to take a full ownership, but the Act does not impose a disability on the powers of an owner to make disposition in accordance with his wishes. Section 14 subsection 2, which may be considered as an exception to Section 14 subsection 1, to the general rule incorporated under Hindu Succession Act, protects the power of an owner to settle the property in accordance with his wishes. Hence, where a female receives a limited interest in a property under a decree of a court or an award, or under a gift or a will executed by an individual, such limited ownership would not be affected by Section 14 subsection 1 and would not mature into an absolute ownership or an absolute interest. Section 14 subsection 1 is very wide in its application, but Section 14 subsection 2, being an exception, has a very restricted application. Where a female acquires property under a will or gift and the case is covered under Section 14 subsection 1, the limited interest would mature into absolute interest, but where it is covered under Section 14 subsection 2, the limited interest would remain a limited interest only. The test to determine whether a case would be governed by subsection 1 or subsection 2 of Section 14 of the Hindu Succession Act is that, irrespective of whether a woman receives the property under a gift or will, if she receives the property in recognition or in lieu of her pre-existing rights, then it would cover under Section 14 subsection 1. And if she receives it because the grantor wanted her to have a limited interest, then the case will be covered under Section 14 subsection 2. There are conditions which the court suggested to be satisfied to apply Section 14 subsection 2. Let's see what are those conditions. Firstly, that the property must have acquired by way of gift, will, instrument, decree, order of the court, or award by any of the court. Secondly, that any of these documents executed in favor of a Hindu female must prescribe a restricted estate in such property. And thirdly, that the instrument must create or confer a new right, title, or interest on the Hindu female, and not merely recognize or give effect to a pre-existing right which the female Hindu already possessed. That's all for today. Thank you.